Yes, Mr. Westgate.
Yes, I was going to go on to the anomalies that caused the judge to depart from what we say is the inevitable reading of the regulations. But before coming to those, we do want to address a point about the way that the regulations work, and I hope in doing so to pick up some of the questions that came from the court. The first is about the difference between what is debts that are due and those that are owing, and how that fits into the framework of the regulations. Because the starting point in Regulation 5...
I'm sorry, I was coughing while you were making that
Yes.
submission. What was Regulation 5?
Regulation 5
Yeah.
refers to a qualifying debt, meaning any debt or liability
Yeah.
other than non-eligible debt. And then if we go to Regulation 6, we see that the definition of a moratorium debt is a debt that's owed by the debtor, that's 6b, at the point at which the application for the moratorium was made. Now, of course, debts can be owing but not due,
Yes.
and the definition of arrears draws a distinction between carves out those debts that are due in respect of secured debt. And so the way that the regulations work is that for nearly all debts, they go into the moratorium if they're owing, even if they're not then due. Credit card debts, for example, some of it may be due, but there may be a significant amount that's owing. And secured debt stands outside that because it doesn't go into the moratorium unless it's arrears and so due. And that, we suggest, explains the emphasis on being able to pay debts as they fall due, because for most debts owing, even if they're not due, the effect of them going into the moratorium will be to pause the future liabilities that they generate. And therefore there is sense in relieving a debtor for pausing the obligations on the part of the debtor who is, for the present, unable to pay their debts as they fall due. That, of course, raises a question about why should secured debts be treated differently. And when being taken to the provisions, my Lord Justice Zacaroli made the point that the reference at page 534, paragraph 7.8, was about certain public debts. And what the pre-legislative material seems to talk about are the debts that are not discharged on bankruptcy. And they focus on things like fines and fraud obligations and so on, and things where, in effect, there's a public policy in not allowing those to be discharged. But the pre-legislative materials tend not to focus on secured debts in that framework, and it may well be that the reason they fall into don't fall into the moratorium and continue to generate liabilities that have to be paid is their importance in fashioning a durable debt solution. That if someone can't meet their secured debts, which tend to be on the more important items on a continuing basis, then it may be difficult to arrive at a debt solution that deals with all of their indebtedness. And so one keeps that going, in effect, as a discipline on the debtor, and to encourage them to engage with a debt solution. And so it's all part. It's part of the balance struck by the regulations to preserve those obligations, but it doesn't, we suggest, do so necessarily by analogy with insolvency provisions. It does it by reference to the exigencies of fashioning a debt solution. And some clue to that might be found in the pre-legislative materials. There's a Treasury response to paragraph 3.31 that talks about ongoing liabilities on secured debts on essential items, such as those being a mortgage or on hire purchase items.
What was that reference?
It's 3.31, page 468. And just before leaving this point, an issue arose about ongoing liabilities and why those arise in a breathing space moratorium and not a mental health crisis moratorium. Part of the answer to that is found in the passages I referred you to about the treatment of mental health crises. But that ongoing liabilities, or the obligation to pay ongoing liabilities, is a discipline on the debtor that may result in a breathing space moratorium being cancelled on the halfway review if they're not being paid. Most, if not all, ongoing liabilities are outside the moratorium. In fact, Regulation 11 seems to be framed on the basis that they are all outside the moratorium. And so they are still liabilities that fall on a debtor in a mental health crisis moratorium. It's just that the policy behind the regulations is not to subject them to the same kind of penalty if they fail to pay, and that reflects the different routes into the moratorium. If I come on to capitalised mortgages.
Can I just ask this before
Yes, of
we move
course.
on? So Sir Anthony Mann relied on the fact, I think, that a secured debt which was owed, a secured debt which was not due was not owed under the moratorium
Yes.
definition. In support of the argument, in support of rejecting, I think, your argument.
Yes.
So you would say he was wrong about that?
Yes, we would. And the reason that secured debt doesn't go into the moratorium isn't because it's not a debt for the purposes, it's because it's non-eligible unless it is arrears.
Yeah.
And that we suggest is key to understanding the purpose that's served by keeping the secured debt outside the moratorium, even when there are no, even when there are no arrears, or even when not all of it is in arrears, because if it goes into the moratorium, there will be moratorium consequences that go beyond protection from enforcement, and the debt's then protected from those consequences. If I can come on to capitalised mortgage arrears.
Yes.
What particularly influenced the judge was an anomaly said to arise if capitalised mortgage arrears are outside the moratorium, but the rest of the sums are inside the moratorium, so that the creditor can enforce on the capitalised mortgage arrears, but not on the rest of the outstanding debt. That, he says, is an irrational anomaly. And we agree, but we say it doesn't arise. Our response was the same, really, as Mr. Cunningham's, that the definition of capitalised mortgage arrears as sums that have been added to the outstanding balance to be paid over the duration of the mortgage, that's taken from Regulation 2, has no meaning once there is no duration of the mortgage, because it's been called in or has come to an end without the sum due being paid. And therefore, capitalised mortgage arrears are only part of the treated as being part of the or treated as not being due or not being arrears, so long as they fall within that definition of capitalised mortgage arrears, and they therefore stand with the rest of the debt that's due and hasn't been paid, and they fall within the general definition of arrears once the mortgage is called in or it comes to an end.
So just looking, what words is it specifically in the meaning, the definition of capitalised mortgage arrears that you say supports that interpretation?
Well, it's added to the outstanding balance to be paid over the duration of the mortgage.
Have been added.
Well, we appreciate that it starts with have been added, but that's a phrase that can import that condition still being continuously satisfied, because it makes perfect sense if something says, well, this has been done, and then at the time the speaker is speaking, it's been undone, or that then it's not an appropriate use of language to say, well, to rely on something having been done in the past is misleading.
Let's just test that by seeing how it works. If you put that phrase into arrears, the definition of arrears.
Yes.
Arrears means any sum other than those arrears in relation to a mortgage that have been added to the outstanding balance to be paid over the duration of the mortgage.
And it can only make sense if there is a duration of the mortgage to which that can apply.
Well, at the time they were added. Doesn't it mean at the time they were added, there was a mortgage. There was a mortgage which was enduring, whatever the verb is. So why are past capitalised arrears not covered if they were added in the past, which was during the duration of the mortgage?
Well, it's the question comes to be addressed at the point of the application for the moratorium, and at that point there is no duration of the mortgage.
But there was when the time that, what if there was a duration of the mortgage at the point they were added?
Well, there will be, but in any case,
Well, why are those? Why are those? Why is that type of capitalised arrear not excluded?
well, Lord, it does depend on the reading of capitalised mortgage, the reading of have been added, importing in this context a continuing state of affairs.
Yes, have been added. That is the past tense, isn't it?
Well, yes, it is, but it's one that is certainly apt in ordinary language to cover something where it deals also with the present state of affairs or a continuing state of affairs. If it was intended purely to deal with the situation where you're looking just to the point when they were added, then the appropriate phrase would be were added rather than have been.
If your interpretation would require excluding the words that have been, wouldn't it? If it said added to the mortgage, it would be capable of, there would be no specific time at which that happened. But have been mortgage, doesn't that imply something that's already happened?
Well, it can only have happened in the past, but the question is whether the statutory wording is apt to cover something that is no longer in existence. So if one asked at the time that if the mortgage company wanted to enforce against capitalised mortgage arrears, and the mortgagee said, well, these have been added to be paid over the duration of the mortgage, and the fact is at that point, the point is that becomes relevant. They are no longer.
Doesn't your interpretation require omitting words that are in the definition and adding words that aren't?
Well, we would suggest neither. I mean, it certainly doesn't involve adding words, but it involves reading have been added in context as covering a case or requiring that the conditions still be satisfied. And we would suggest that it ends up doing less violence to the language than is required by the defendants, the respondents' reading.
You mean less violence to the language of the regulation as a whole? Because
that's
the
right,
way
yes.
the respondents require us to read,
Exactly.
to read arrears.
Exactly, and the reality is that this is something that really takes the use of anomalies to resolve difficulties in interpretation to its absolute limits, because this isn't an anomaly that flows automatically from the inclusion of the main debt as arrears. What it is we would suggest a particular reading of the definition of capitalised mortgage arrears, which isn't required, but which is being pursued in order that one can then say, but that's an anomaly that we then have to use in order to reinterpret Regulation 5.4a, when the meaning of Regulation 5.4a is, we would suggest, perfectly clear. So it's not the normal kind of anomaly that arises if one would have such a thing, that arises automatically from a particular construction. in a sense, it's a. I'm not going to use the term manufactured or artificial, but it's something that is alighted on to.
You say that as anomalies go, it's anomalous.
Yes.
Abnormally anomalous. Anyway,
I've taken up too much.
you
time.
have, is that, partly because of my intervention, but thank you very much.
But I think everything else we want to say is in the skeleton.
Thank you very much, Mr. Whiskey. Who's going next?
It's
You are.
me.
Mr. Eagles.
Rawls, may I begin by giving you a quick roadmap of how I wish to use my time? It's been agreed I have an hour and 45, but I'll try to be much quicker than that. Let me start by saying that I won't cover the facts as a point of statutory interpretation, but the facts in the Interbay case are set out in the judge's judgment at paragraphs 5 to 12 in the core bundle tab 8, pages 84 to 86. To the extent that any particular facts are relevant, I'll address them under each ground. I'll start with ground one, which is, as we know, whether the called-in capital of the secured debt is moratorium debt or not. Your Lordships already have the benefit not only of Her Honour Judge Evans Gordon's judgment and Sir Anthony Mann, but also His Honour Judge Parker in Bluestone also came to the view that the called-in capital was not moratorium debt. We say, because of the way the regulations are drafted, we recognise there's no very obvious answer, and neither party's case presents a perfect solution. However, like all those judges that have wrestled with the called-in capital question so far, we say our construction is preferable and avoids some of the more absurdities, or should I say anomalies, of Mr. Forbes's case. My key point on ground one is to understand the intention of Parliament. We have to look at the definition and the impact of excluding capitalised mortgage arrears, because that they are added as an amalgamated sum to the capital, which implicitly means the capital must be excluded. And we say, my learned friends have come up with no convincing explanation as to why capitalised mortgage arrears would be excluded, but the capital would not be. And my other key point will be that their construction disturbs the balance between the regulations, which have quite a dramatic effect on secured creditors, who may not always be banks or lenders, but individuals, by bringing in a very large capital sum within the moratorium means no interest, but also, as you saw under Regulation 710, you can't recover that interest when the moratoria ends, and as you have seen, that can go on indefinitely. Yes. I'm then going to address my alternative grounds if ground one goes against me. The point here is Mr. Forbes' moratorium never in fact included the called-in capital, regardless of the court's view on whether that is moratorium debt or not. That's because the debt advice providers here, who are the arbiters of, at least initially, of what's in and what's out of the moratorium, when asked to formally review the moratorium, made clear that capital of any kind, called-in or not, was not included. And as such, it was never registered on the register required under the regulations. And as we'll see, there are three, even if you are a qualifying debt under Regulation 5, you then have to be a qualifying moratorium debt under Regulation 6. And the third cumulative requirement is that it is that the debt or information about the debt is registered on the register. And as we can see here, it wasn't, and still, as I understand, wasn't before the judge and not today. Then I will address ground two. Now, I did flag this in my skeleton. This may have an impact on time. I had understood ground two as initially presented when appeal was given by Lord Justice Lewison as being parasitic on ground one. In other words, if you hold that the capital called in comes within the moratorium, it can't be enforced against. But as I pointed out, my learned friend appears to have expanded that somewhat in the replacement skeleton to include this broader point, which is quite a complex point about whether if you have mixed debt or security, you still can't enforce without permission. Now that is the subject of the Bluestone case. And I think, my lord, you asked my friend to identify what specific bits of Regulation 7 in that latter part of ground two my learned friend was attacking. So I know that I think that Bluestone case is going to be subject to an appeal.
Yeah, well, it has.
I don't know whether it's been.
We think an appeal notice has been filed. Is that right?
Yes. I am ready to address this, and I addressed it in my supplementary skeleton, but this wasn't a point raised below as to this mixed debt and mixed security point. but I will at least briefly deal with it. And my learned friend didn't develop it this morning beyond raising it.
No.
But I think it's right to flag that that is a significant other issue that the court may have to...
Is it an issue of some importance generally?
Yes, it is, because what it would mean is even if the capital called in was not moratorium debt, or even if, for example, you had, say, a breach of the mortgage, taken insurance, say the mortgagor had not taken out insurance, put the property at risk.
Yeah.
What the decision of Mr. Justice Mellor in Bluestone says is that even if you seek possession on that non-financial ground, because the security could be held in respect of moratorium debt, say a debtor owes a few arrears prior to a moratorium, when you come to enforce, based on the breach of the finance documents for the insurance breach, that inevitably or unavoidably involves enforcing in respect of a moratorium debt.
So it affects the whole thing.
Exactly. Now, it might be that the court takes the view that only arises...
If you lose on ground one.
Well, yes, but I mean on a sale. So in a sense, this wouldn't arise, it might be said, until you seek to sell the property, because it would only be at that point, potentially, that one is having to segregate...
Are you suggesting that this is an issue which, in fact, might require wider argument before a court could deal with it safely and comprehensively?
I think, subject to the court's view, I think I am saying that,
So
but I am ready to deal with it.
If we're with you on ground one, then you would say don't think about not considering ground two. Is that right, how it works?
I think the problem is that ground two, as I say originally, when permission was given, was expressed to be parasitic on ground one.
Yeah.
But it's been expanded such that even if we win on ground one, they're saying we can't enforce because it's a mixed debt or security.
Is there any issue about whether that way of putting the case is open on this appeal if it was not taken below?
Well, I did raise this, my dear friend, in both my original skeleton and the supplementary skeleton. I didn't want to interrupt at the beginning to deal with this, but I would say yes, because of course, one of the things, we didn't ask for permission. If we needed to ask for permission, that might have been something we'd done in the proceedings. But of course, it wasn't dealt with below. And my only concern is it is quite a complicated, far-reaching point, as Mellor, Jay, and His Honour Judge Parker said, it could affect any mortgage that's subject to any moratorium debt even if you're trying to enforce in respect of something that's not within the moratorium. So as I say, it is dealt with. My own friend respectfully didn't develop it this morning. And I think, as I understand it, it seems to be an argument in relation to 77C, which is enforcing in respect of security,
Yes.
or possibly 77F,
Yes.
which is when you bring a claim
Yes.
that includes two things. I don't think it could be said that it's 77B, because that is
Mr.
enforcing...
Justice Mellor dealt with 77C, didn't he?
And B.
And B.
But we're not...
We're in 77F territory, aren't we?
Or, well, this is what I've been trying to grapple with, because I don't know if my learned friend's also saying, by bringing possession proceedings and getting an order, that is also, I think he is.
Well, so are you content to say, to rest your case on that, on your written submissions, but invite the court to hear from Mr. Cunningham in replies to whether or not it's open to him to take the point?
Perhaps I don't want to take unnecessary procedural points, and if it matters before the court, I can deal with it. But I think, subject to the court's view, I'd be happy with that approach. But I just raise it because it is quite called in capitals an issue in itself, but it's a whole nother debate, as it were.
Well, the reason why you say we should be strict here and not allow Mr. Cunningham to take the point, if you're right, is it has wider ramifications which have not been fully developed in argument so far.
Yes, including in this appeal and below. It wasn't taken at all.
Okay. Yes, that's ground two.
And then I'll deal briefly with ground two, which was ground two below. And this is slightly similar to the ground two or expanded ground two point, but slightly different. This is the argument that by bringing an alternative ground for possession based on the breach of tenancy, allowing tenants to occupy the property, by merely bringing that in the same claim form as the called-in capital debt, assuming called-in capital is moratorium debt, it's dead by association. Now, the judge dealt with that quite robustly in the judgment. and we can see that. But that's the third.
But it also goes back to ground two, doesn't it?
Well,
If you're enforcing for a non-financial reason, you're enforcing for the debt.
Yes,
In fact, you're possessing the, getting over possession to recover the debt.
yes. Although ground 3, as it is now, is about 77F, which is if you can start a claim. It's not about enforcing
No, it's
security.
not put that way, but it would run up against the same problem. Even if you brought a separate claim,
Yes,
seeking only possession on the grounds of breach of a non-financial covenant, when you get possession, you're getting possession in respect of a debt, which is a moratorium.
yes. And one of the reasons we say that's wrong is because, of course, you could just get a charging order, which is not prevented, on your non-moratorium debt, and then enforce only in respect of the non-moratorium secured by the charging order. But we say that shows that's not what secured creditors should have to do. Finally, ground 4, I think, is genuinely parasitic on the others, which simply says if the appellants are right about grounds 1 to 3, then the order is null and void. Finally, I should say, my learned friend, Mr. Morris, for the Seculink, he will address the court for around 30 minutes, focusing on the statutory principles of statutory construction, including the principle of legality, which we say is important given the interference in secondary legislation with security rights. And he will also address Mr. Westgate's attempts to explain away the express exclusion of capitalised mortgage arrears. And so if I could move on to ground 1 as quickly as I can, which is whether the moratorium debt includes the called-in capital. Can I briefly go through some materials on the purpose or policy of the regulations? Can I turn to volume 2 of the authorities bundle in the Interbay appeal and look at tab 24. And this is the 2019 Treasury Explanatory Memorandum, and it's 533,
Yes.
volume 2. You'll see that it's been marked in the left-hand column. Just to stress that the primary policy objective, it's often we're focusing on the money, as it were, but it's actually time. It's to incentivize people to enter and take advice to find a meaningful solution to their circumstances. It's a respite, it's a breathing space, not an immunity. And then if we turn over the page, we've looked at this earlier, page 547. And if you just look briefly at 7778, we then had the point we saw earlier about bankruptcy. Can I also just draw your attention to 711 about moratorium not being a payment holiday? Now, I appreciate that may be said, as has been said earlier, to be in respect of a general debt moratoria. But while we're on this page, can we look at 714, the last line? Yes, there may be differences, but when it comes to what debts are in and out, there is no difference in that regard. 714. Can I just pick up on the insolvency reference that we saw earlier and again at 7778, by looking at briefly a decision of Mr. David Locke, KC, sitting as a Deputy High Court Judge, where he says that it's important to construe the regulations consistently with the provisions of bankruptcy. I don't think I need to take the court to the fact that, but I will actually very briefly. If we could just look at the Authorities Bundle, Volume 1, Tab 2. This is the insolvency, parts of the Insolvency Act. And if we could go to page 5, section 251G, you'll note there's similar terminology being used here, moratoria and qualifying debts. And then if one goes over the page to subparagraph 5, nothing in this section affects the right of a secured creditor of the debtor to enforce his security.
This cuts both ways, doesn't it? Because 251A also says a debt is not a qualifying debt to the extent that it is secured. So first of all, it's dealt with differently.
Yes.
Secondly, it takes a more nuanced approach to security, which you've seen in bankruptcy, which is a debt can be part secured and part not.
Well,
These regulations don't.
exactly. I think there is a distinction, you're right, in other sections of the Act about treating them as two separate parts of the petition. Can I just briefly look at that decision that I mentioned? It's in the Authorities Bundle, Bundle 1, tab 11. This is a decision involving us in mental health moratoria. Can I ask the court to look at page 206?
Do we need to worry about the facts of this case or not?
I don't think so, my lord. I think it's sufficient to say that they're at the start, but they do concern a mental health moratoria. But I don't take any particular things from the facts. And if I could ask the court to just read very 23, 24 and 25.
Yes.
And the insolvency reference is halfway down 24, where it says the reference to some or all.
Because the breathing spaces is granted so that there can be time to discuss, to come to some consensual, maybe I think the word is including non-statutory scheme for repayment. So it isn't assuming the only way out is bankruptcy. Right? Am I misreading?
No, I think he's making the point that it could lead to a bankruptcy situation, and it would be odd if when one enters an IVA or seeks a debt relief order, that the debts would be different that were covered under the regulations and the insolvency regime. I think that's the...
If we're going to, if the purpose is to enter into some form of statutory compromise or relief, whether a debt relief order or an IVA or bankruptcy, then I can see the point that, well, if that's the only outcome, then surely security has the same meaning. But even then, we see it doesn't.
With the part security, you know, I see that, and there, as I said at the start, where one is looking for clues rather than hear answers, and obviously it doesn't specifically address whether called-in capital is part, but it does suggest the importance, if secured debt is to be excluded, as it is in insolvency, if one is bringing in the called-in capital, or it's not just the called-in capital, it could be when the capital is due at the end of the mortgage. When the term is expired, it would also then become due. So it's not simply being called in. And to, as I said earlier, to bring that into the moratorium is a significant departure, at least compared to the Insolvency Act. Can I now ask the court to look again at what the judge below said about the purpose of the regulations, and that being consistent with her construction? That's tab 8 of the core bundle. And it's paragraph 31 of the judgment on page 94. And could I ask the court to read about halfway down, if you can see on the right hand side, in my view. You've looked earlier at the earlier part, which is about capitalised arrears. Can I then ask the court just to have a quick look, in case it or to reread, just paragraph 32, and then my lords, we say that the purpose is supported by the fact that, as we've seen earlier from the definition of arrears and what is a moratorium debt, the fact that missed payments after the moratorium as applied do not fall within the moratorium, can be subject to enforcement and interest, suggests, supports the idea of that purpose. Can I now turn to the language of the regulations, having looked briefly at some of the purpose? If we could go to the Authorities Bundle, Volume 1, Tab 4. Page 24. So, as we saw earlier, a qualifying debt is defined negatively in terms of everything that isn't excluded. We say it's therefore important to preserve the few exclusions that there are. And then if we go over the page, we go to 5.4, we see what we've been looking at earlier, secured debt which does not amount to arrears in respect of the secured debt. Now, we accept that the definition of arrears is wide, as did Sir Anthony. However, that doesn't mean that it includes the principle, the thing itself, of the debt, and it must be seen in the context of the regulation 5.4a and the regulation as a whole. That contextual analysis is important because Mr. Westgate did pick up on it. There is another reference to arrears. It comes in the definition of capitalised mortgage arrears, and I don't think it can be seriously said that the definition of arrears in capitalised mortgage arrears is referring to the definition above it of arrears. That's the other time that it's mentioned. It also gets mentioned in Regulation 7. The rather, I think it was said to be an anomalous reference. It's Regulation 7.7 K, page 29. So if you serve a possession notice, and then it talks about rent arrears. So obviously one has to bear in mind the context, because if you read the definition of arrears into that, it wouldn't make much sense. My submission is that arrears is belts and braces drafting because of the type of sums that fall due when one doesn't make one's monthly payments. Suppose it didn't have a definition of arrears. We would, I'd submit, understand that phrase to mean the missed monthly payments. That's what's conventionally understood, monthly missed repayments. But of course, when you go into default and you don't pay your monthly repayments, there are lots of other sums that become due. For example, interest, penalties, charges, receivers' costs, if applicable, legal costs. These are all added, as you saw from the statement earlier, to the arrears. So we say it is necessary to have a wide definition, because if you just said arrears in the conventional sense, monthly missed repayments, that wouldn't be enough. And of course, whilst we know that the Regulation 7 excludes interest and charges on the moratorium debt, that doesn't answer the question of what's in the moratorium debt in the first place. And we say that the broad drafting of arrears is to make sure that it's not simply the monthly missed payment, but other charges falling on that.
Why can't it be all payments due under the agreement?
Well, the agreement is rather circular because secured debt is defined as a credit agreement and then it goes back. I don't know if you picked that up from Honourable Judge Evans, but it's still, we say, because of other reasons, including capitalised mortgage arrears, that even if it means agreement, it doesn't tell you whether that should include or does include the capital of the debt. But as I say, I'm seeking to explain that why it may be a broader definition, and that reason is not because it wanted to cover the capital.
It's not just interest, it includes costs, legal charges.
Yes, because if you just said arrears, that someone could say, well, that just means the monthly missed payment. And this is making clear that it also includes the default fees and, you should say, the cost.
Does it include the monthly capital payments?
Well, I was going to come to that, my lord, but I can address it now. Just to say, to be clear, we never said, and neither did Her Honour Judge Evans Gordon, that capital, even monthly repayments of capital, were moratorium debt. Her position and our position, it may be different in the other case, it has been that capital, she says in her judgment, capital, whether due or not, it is never part of the moratorium debt. And we say that is consistent with reading the regulations as a whole. So we don't accept that capital could ever be part of that. And that's why capitalised mortgage arrears is important, because why are they being taken out of the definition of arrears? They are being taken out by dint of their status as being added to the capital. That's what's stopping them being arrears.
The typical debtor will never know, will they, how much of each monthly payment is capital and how much is interest. It'll be different over the period of the loan. They'll just be told you've got to pay back so much a month.
I think, my lord, it is possible to find out the proportion either at the beginning of the mortgages and it goes on as to what amount of the capital you're repaying as opposed to the interest. Of course, in this case, it's an interest-only loan.
Yes.
I'm not saying that is an answer to the point.
Well, don't we have to test it by see if it all applies to repayment mortgages?
Yes, I see that, but we say...
I mean, the notion in a repayment mortgage, every single instalment includes an element of capital repayment, even if it's only a tiny amount.
Yes. No, I see the point. But
for an early stage of your mortgage career, you'll know that it's rather depressing if you're on a repayment mortgage. Don't worry, you get to the point where eventually, it all gets paid off. But even the small, every repayment, every instalment has a tiny element of repayment.
Yes, and as I say, we say the fact that the capitalised mortgage arrears is excluded is an indicator that even just because the capital is due by being called in as opposed to a monthly payment, we say that doesn't matter. The capital, the thing itself, the secured debt, it is never, as the judge said at 31, is never part of it. So our primary case is that it doesn't fall to the capital whenever. But if we're wrong about that...
Can I just ask, what about a hire purchase agreement? Because that's the same definition applies across the different types of secured agreement, doesn't it?
I think there's a separate exclusion for hire purchase agreements.
Is there?
I may be wrong about that. No, I apologise, my lord, you're correct. It would fall with, it's one of the categories.
Hire purchase agreement, although for tax reasons, you may be required to separate out which element of each monthly payment represents capital and which represents interest. So far as the punt is concerned, they just have a monthly sum to pay. But you would say that you have to, part of that is a moratorium debt, part is not if it's in arrears.
Yes, but we'd also say there's still arrears in respect of the secured debt. It's still, if you've still got the capital, but you've got the arrears, in this case would be the interest and the capital on that capital. So there's still,
Well,
there's-
part of it of, and part of it's on.
Yes, no, I'm saying if I'm wrong about that, and the capital part of a monthly repayment can be arrears, that doesn't mean that the capital itself becomes part of the sum when the whole of it when called in, because there would be nothing to be in respect of if all the capital is due. They're still, even if they are subject to being arrears, the capital and interest are still in respect of the much larger capital sum. So the capital itself, when it's called in, is different. So we say even if the monthly repayments can be arrears, it's still arrears in respect of the capital, which is excluded. Can I just turn to the in respect of point on that? A lot of the time's been spent thinking about on and of the detriment parties. But our point is that in respect of is different to of, could have used of, they use in respect of, and it's creating a distinction between the arrears and what they're in respect of. And if the whole sum is due, there is nothing left to be in respect of. And that was, as you saw from the passage earlier. And if one sees it this way, if one goes back to 5.4a on page 25, suppose we stop the sentence after the word arrears. On my learned friend's case, that's all they need, secured debt which does not amount to arrears. So that could have whatever arrears includes. So why add the words in respect of secured debt? Because already know it's relating to secured debt because it's the first bit of 4a says secured debt. So we say that sum has to have a meaning, and it only has a meaning because it follows arrears, i.e. when the sums become due. And in that context, when the sums become due, they must be arrears in respect of the secured debt itself, the capital. So we say, what do the words in respect of secured debt mean? Because on my learned friend's case, they're not necessary because they could just stop after the word arrears. The fact that other exemptions involving non-secured debt, for example, council tax, use the word in respect of, is, as Sir Anthony Mann said, neither here nor there. If given it's been raised, just quickly look at it. It's 5
H,
page 25, 26.
when it's used at H.
It's
And
K, it's 4K, my lord. And any liability in respect of council tax. I think the point Mr. Westgate makes is in respect of must include the thing itself in that context. But of course, what that really means in that context is liability for council tax. You wouldn't say any liability on council tax or in that context or of council tax. So we say in respect of is an amorphous phrase. It depends where you use it. We've seen it used lots of different times.
It's used on student loans in H.
Well, and Regulation 7, when we saw what you can do and can't do in respect of a moratorium debt, we say it's not, as the Supreme Court's recently held, like certain words such as a woman, it doesn't need to mean the same thing in every place. The word in respect of is contextual, and it depends on what's surrounding it. It's an amorphous phrase. Can I then come to the key point on capitalised mortgage arrears? And can I just take you to what Sir Anthony Mann said about this? We've looked at what the judge said in my case, but that's found in the Authorities Bundle, Volume 2, tab 17. And it's at paragraphs 28 and 29 on page 378. The court may have already considered this, I don't want to, but I just would emphasise those 2 paragraphs.
This is Sir Anthony Mann's judgment. yeah?
Yes, my lord. In Seculink.
You rely on the last part of 28.
Yes, and 29. And additionally, of course, we say it's anomalous, if that isn't a loaded phrase now, that there'd be much smaller arrears that you could afford force on, capitalised mortgage arrears. So it's strange that the smaller CMAs can be subject to the moratorium, to enforcement, not an moratorium, but the much larger capital sum not.
That may assume a particular reading of Regulation 2. Is Mr. Morris going to deal with this definition of capitalised mortgage arrears?
He is, but I'm going to deal with it now and make 4 points.
Can I ask this then? So, in the definition of arrears,
Yes.
I think the key question may be in the second line, what does the words "which has fallen due" relate to? And there seem to me to be 2 possibilities. One is that part of the outstanding balance which represents the capitalised part of what was formerly interest, that part of the balance. Or it means the interest which was outstanding, but which has now been capitalised. If it's the former, then your argument is stronger. But if it's the latter, that provides an explanation, doesn't it, for the whole of this? Because what this is doing is saying, well, arrears generally would be a moratorium debt, but not those arrears which have now been capitalised. Those are now taken out of account, which tells us nothing about what then one does with any amount of principal that is now due.
But the reason they're taken out is because they're added to the capital. It's their status as being added to a singular amalgamated capital sum that is the reason they lose their not arrears. It's because that's the reason. So the point is, if perhaps I'll just get in my submission that interest payments being added to the capital is what makes them no longer arrears. So when you're adding them to the capital, so you then have to make an artificial distinction between the bits that have been added and the capital itself. We say that's an odd distinction to make.
On the interpretation I just gave, it's not distinguishing between the bit that's the 2 bits of the principal, capitalised interest, and the rest. It's distinguishing the types of arrears. Let's assume it's just arrears of interest. Just make that assumption at the moment. Then there could be arrears of interest which are still sitting there, and arrears of interest which are no longer sitting there because they've been capitalised. So those are taken out of account so far as arrears is concerned because they're no longer due. It may be belt and braces because actually the fact that they've been capitalised means that it's no longer due.
Yes, well, I think you made the point earlier that capitalised mortgage arrears wouldn't become due simply by being added to the capital balance. It's only once the capital is called in that they would need to be excluded from arrears. Because if they are just added to the balance, why would you need to exclude them from arrears? All sums, I think arrears is not due and owing, it's actually due. So we would say that the reason they would only ever become due.
So is that different? Is due and owing different?
Well, I think when you look at arrears, one doesn't have this fine distinction, if there is one, between due and owing. It's just sums that haven't been paid by the date of the application.
It must be due.
Yes, but not owing. There isn't this distinction between due and owing. I think we heard.
Well, I think there is in the background. It's just that these aren't merely owed. These are those which are owed and actually are due and have become owed.
But my point, my lord, is that they would only ever become due and therefore need excluding from arrears if the capital to which they have been added also became due.
If which has fallen due refers to the capitalised sum, as opposed to refers back to the arrears which gave rise to the capitalised sum.
Yes, I see that. But I see, as I say, it would be anomalous to add that what makes them not arrears. It's the fact they are being added to the capital. So to then say that this singular amalgamated body of debt of the capital is excluded, it is not excluded, but the arrears added to them are. I think what one might say, no reason has been put forward as to why capitalised mortgage arrears would be excluded by the drafters, but not the capital. And we say it's indicative and reflects the assumption that capital is not moratorium than debt. I suppose one might also say, to develop a point that was raised, why, if capital is excluded as a generality, why do you need to have an exclusion of capitalised mortgage arrears? Which is sort of coming to the same point. But I think that what it's doing is saying when the capital is called in, someone might turn around and argue, well, hang on, that bit of the capital that you've called in or is otherwise due, that originated from interest payments that were added to the capital. And so those should be in the moratorium. And I think what we say is that CMAs, it's clarifying that because they've been added to the capital, that they are also excluded from the moratorium debt.
That's the exact argument I just put to you, isn't it? Which is the reason they're singled out is because someone might say, well, they were arrears,
Yes.
which had fallen due, but we should take them out of the account because actually they've been dealt with separately. They're no longer due because they've been capitalised. So it's to stop that argument.
Yes.
But that says nothing about how this is meant, what is meant to be, how capital itself, whether the principal amount or the additional.
But I suppose you'd only be having that argument in a situation where the capital itself has become due. So it assumes that the capital is excluded, and therefore someone needs to make the argument that these particular parts of the capital remain capital, and by dint of their origin as being interest, they are nonetheless excluded as well. So we say it's, to say it isn't clear. It seems to me, my lord, to answer your question, that it rests on the assumption that A, the capital's been called in, and it's necessary in those circumstances to spell out that the capitalised mortgage arrears remain excluded as well. In terms of the arbitrary results that Sir Anthony Mann and Her Honour Judge Evans Gordon considered, those were that the construction of Mr. Ford places a very large weight on the act of calling in the loan. Now, many secured loans, contrary to what has been said, are all money's charges and are likely to be called in if there are mispayments. It isn't, as has been suggested in Mr. Wessex Skeleton, something that's designed only to deal with longer term mortgages where you have a long period where arrear payments are made. And as both judges below have said, they were uncomfortable with the idea that a lender who happened to call in the loan the day before a moratorium couldn't enforce the debt or charge interest, but somebody could, the day after a moratorium, despite somebody suffering a mental health crisis, then call in the capital. And as my learned friend confirmed this morning, there's nothing wrong with that after the moratorium has started. And both judges found that an uncomfortable result of my learned friend's construction. It may, for example, encourage a debtor to run up more debt before he or she applies for a moratorium, which of course the lender doesn't know about until it's granted and notified to them. It may encourage debtors to wait for a loan to expire before the moratorium, before they apply for the moratorium, and then all the capital as well as the arrears would be within the
Or
moratorium.
if they, on the day before the capital fell due.
Yes, if they waited, for example, for the loan to end and then applied for moratoria, everything before the moratoria is in. Whereas if they'd applied when they'd missed payment 5, then we could then call in the capital.
Right.
And we say it's also important, as Sir Anthony Mann held, to consider bringing in the calling capital, the practical and commercial effects of that to creditors, who, as I mentioned earlier, will not always be banks or lenders. Of course, they have their own liabilities in borrowing as well. And that's Regulation 7.10, if we just look very briefly at that. Tab 4 of Authorities Bundle 1. And it's Regulation 7.10.
Page
and it's found at
29.
29. Thank you, my lord. So this confirms that after the moratorium has ended, which that could be a long time, you can't recoup the interest that you haven't charged during that period. So you can't charge it, but then you can't get it back after the moratorium has ended. So it's and also it isn't like an enforcement step where you can get permission, which may or may not be granted. You can never charge interest on a moratorium debt, and you can never recover it afterwards. There's no permission regime as there is with enforcement. And in this case, just by way of example, the debt was around over 1.3 million. So interest cannot be charged on that rather than £95,000 of arrears, which has a very significant impact, and we say disturbs the balance of the regulations, which should not absolve debtors from the debt itself, but should be focused on the arrears of the debt.
The debt was unsecured.
Yes.
The debt was unsecured but payable in the future and interest payments every month. That would be the consequence, wouldn't it? In your case, you'd accept that.
Yes.
The debt is a moratorium debt, even though it's not due until after the date of the moratorium. It's owing them. Do you agree with that proposition?
Sorry, mate, could I just...
At the date of the moratorium commencement, there's an unsecured debt which is due for payment in a year's time, with 12 equal monthly instalments on the way through of interest. I think you accept that that's a moratorium debt because it's a debt that's owed at the date of the moratorium. But if you don't accept that, say so.
I think it would be difficult to resist that submission.
Due but is owed. The consequence of Regulation 7.6 is you can't be required to pay interest on that debt during the period of the moratorium. And Regulation 7.10 says at the end of the period you've lost the right to interest. So it does have that quite stark effect in the case of an unsecured loan.
Yes, it does. But again, secured loans are given a special status because of the property rights that they grant. So we say that is an important difference. And the carve-out is for arrears. And unsecured debt isn't an exempted debt. So, and the reason it's secured debt is exempt is because it has a special status. And of course, the concern is that even when somebody comes out of their moratorium, as in this case, that there won't be enough equity in the property, which of course is the whole point of having security, to satisfy the debt. My lords, as I say, Mr. Morris will develop some of the capitalised mortgage arrears points. Can I move on to my respondent's notice points?
Yes.
As I mentioned earlier, this is the point that whether or not the called-in capital is moratorium debt, in this case, it was not included by the debt advice providers, MHMA in this case, and accordingly was not registered under Regulation 7.6 to be a moratorium debt. Can I just take you to, it's the regulations again, tab 4. It's Regulation 6, which is found on page 27. It's the definition of a moratorium debt, and it's C, that is a cumulative requirement. So it's not enough just to be a qualifying debt, to be a moratorium debt, benefit from regulations. You also have to put it on the, as we'll see, the register. Now, my learned friend Mr. Westgate, in the other parts of his Seculink appeal, states that it is clear from that the information referred to in Regulation 7.6c that has been provided to the Secretary of State are debts that the debt advice provider considers, emphasis considers original, are qualifying debts. That is what determines whether a debt is included as moratorium debt and whether it is treated as such. We respectfully, in that regard, agree with Mr. Westgate. Also, in the decision we looked at earlier of David Locke, we don't need to turn it up, but I'll give you the reference. It's volume 1 of the authorities, tab 11, page 212, paragraph 45. He confirms, paragraph 45, a debt advisor undertakes a quasi-decision-making process in order to decide A, if the statutory criteria are met, B, whether it's appropriate to grant the requested moratorium. The primary decision maker in this matter under the regulations is the debt advisor, not the court. And if I could just build a little on Regulation 6C, the information, it's any qualifying debt about which information has been provided to the Secretary of State by the debt advice provider. If we go to Regulation 30 on page 43, you'll see this is the determination by the debt advice provider upon an application being made. And if you look at 32, so
30 subsection 2.
Thank you, my lord.
Yeah.
Having considered an application, a debt advisor must initiate a moratorium if the debtor meets the eligibility criteria, conditions met, and then C, the debts to be included in the moratorium are qualifying debts. So they're deciding what's qualifying or not, and certainly at this stage. And then if we go over, if we look at Regulation 30 subparagraph 4 on page 44, one of the things they have to do is, in light of the information provided and information they themselves obtain, so the onus is on them to ask the right questions and gather the right information, to decide whether someone is unable to repay their debts as they fall due. And we say, this isn't just a procedural requirement. If on the register you don't have that someone owes they say they owe £96,000 rather than 1.3, that's going to have a significant effect on whether how you're advising them to repay their debts. And if we also look at Regulation 31, you'll see it says at 2, where the Secretary of State receives the confirmation, they must cause an entry to be made under the register. This is 31 sub 2A. So the Secretary of State has a functional administrative, it's not cross-questioning the decision, but it has to register, it's mandatory. It has to cause it to be put on the register. And then if we look briefly at Regulation 37 on page 47, Regulation 37.1. Any information provided by debt advisor to the Secretary of State under these regulations must be given by the electronic system referred to in 35.1. And if we row back to 35.1, that is the register that I've been referring to, matters relating to moratoria. So the register is available to creditors to know, and that's important because if you're relying on the register and what the debt advisor is telling you, that's going to affect whether you can charge interest on 96,000 rather than 1.3 million. So it is a substantive effect. And again, we don't need to turn it up, but in another iteration, I think there are 4 of the Kay and Lees litigation, paragraph 54, when a creditor sought to challenge information on the register and how it came to pass, His Honour Judge Dyke, sitting as a High Court judge, held at paragraph 54, what is contained on the register, in my judgment, is a matter of record and should be taken at face value. There's no basis for going behind the register or assuming that the correct procedure and process leading to registration had not been followed. That's paragraph 54 of Kay and Lees, 2022, Authorities Bundle, Volume 1, Tab 9, page 173, at para 54. And we say, having the right information on the register avoids, as you may have picked up in this case, the slight confusion as to what is within the moratorium and what isn't in it, which has important effects for creditors managing their affairs as well as debtors. Now, can I apply those points on?
What you do is your point that it must, to be a qualifying debt, it must be on the register.
I'm saying you can have a qualifying debt. So, of course, this is my alternative ground if you think that calling capital is, yes. But no, you have to be there's qualifying debt, then moratorium debt.
Yes, I understand that.
So yes, it has to be under Regulation 6C.
But it doesn't have to be on the register under 6C. It needs to be provided to the Secretary of State.
But that's the only, if we look at what we just looked at, that's the means by which it's provided.
Well, that's not entirely clear. 35.1.
Any information provided by the debt advisor provided to the Secretary of State must be given by the electronic system.
37.1.
Yeah.
The 35.1, that system has 2 purposes. One, it must be a system for giving and receiving communication.
Yes.
And secondly, for maintaining a register. Those are not necessarily the same thing.
No.
So providing information to Secretary of State via an electronic system does not automatically result in its registration.
But I think that being on the register, if you provide something to Secretary of State, I think we looked at 30, if we look at Regulation 30, subpara 2, 43, oh, excuse me, it's 31 on page 44, where the Secretary of State receives the confirmation and information referred to in paragraph 1 above, which is the information, it must, by the end of the day, cause an entry made on register.
So there's 2 different things. There's the providing information, which is part of the definition of moratorium debt. Then there is, once the Secretary of State has the information, he or she is obliged to enter it onto the register.
But I think in this case, my lord, as I'll show you, that distinction doesn't make any difference because the information that was provided was also wrong.
No, indeed, but it's important to know what is the qualifying definition, and it's the qualifying part of the definition. The requirement in order to qualify as a moratorium debt is providing information to the Secretary of State.
Indeed. So if we have a look in this case, if I could take you to the register, as it was before the circuit judge, and I think even to this day, it's in the supplementary Forbes in Interbay Bundle. And it's tab 28 at the back. Page 318, the last page of the month. So you can see there are 2 debts. One is in relation to another property associated with Mr. Forbes, but it's the 95,000 that relates to the arrears at the time of the moratorium for Interbay. It's the second one on the list. Now, the judge explains that they were actually the wrong way round, the two debts, but for present purposes nothing turns on that. It's the 95,000. So you'll see that's what's on the register. It's the arrears, or the amount of £95,000. It's not the capital. And it's worth remembering, this was entered in 2022. It hasn't been amended even before the judge below. And the calling in happened in March 2019. So it's not that it happened, it's a long time before this register entry. And then I would like to take you to a letter from the debt advice provider, in this case, MHMA, sent on the 28th of July to Interbay solicitors, same supplementary bundle, tab 14. So if you look at the Foxley Road and Tulls Hill entries, they got them the wrong way round, as I mentioned earlier. That it's 95 for Foxley
So we
Road.
should read the entry under Tulls Hill. Yes?
Yes, and so in fact the Foxley Road, which is Interbay, the property secured property in this case, is 95,000, as we saw, not 9. So they got the properties the wrong way round. And then if we turn over the page, sorry, it's actually worth noting in respect of the two properties, Mr. Forbes has advised that there is an arrears at that point. And then over the page it says, under the regulations, the capital, this is 235, is ineligible to be included in a moratorium. However, any arrears are eligible to be included, and it mentions what the two arrears are. It was then asked to perform a review under Regulation 18 of what was in the moratorium, what was not. And that's at tab 16, page 237. We just asked the court to read the paragraph.
This is the review.
Yes, this is a review as
By
to
way
what's...
of email. Who is Chris Wright?
He is the solicitor at breaches of the solicitors for the Interbay, who asked them to confirm what was in and out of the moratorium.
Right.
And then the first paragraph confirms that the loans do not include, the confirmed secured loans are not included within the breathing space. And then if one goes down to the second paragraph, and then the paragraph starting, any debt, that's 1, 2, 3, 4, 5, any debt that is ineligible, such as secured loan, is not affected by the creditor's entry into a moratorium. Only debts that are eligible. And then we confirm that any arrears accrued after the initiation are ineligible and not covered. Now, of course, there wouldn't, if you've called in the capital, there wouldn't be any arrears on Mr. Forbes' case after the moratorium, because you called in the whole thing. But anyway, that's what they decided, wrongly or rightly. And on that basis, we sought possession focused on the capital called in debt. And so if one looks at what the judge says about all of this, and if we start, this is core bundle tab 8, page 86. It's paragraph 12. She explains what I've hopefully tried to And then if I could ask you to read paragraph 25. And this is also, as I'll explain, the reason why the jurisdiction point is not the same one in this case. The jurisdiction point was taken below by my learned friend, the same point as Seculink, but it's not taken here. That's what the judge said about it below. 25, page 93. So it's a different situation because in that case there was nothing to apply to court to review, whereas in Seculink the calling capital was included and therefore it was or potentially was incumbent on the creditor to apply under Regulation 19. So it's different, and no doubt that's why it's not being pursued now. But it's wrong for my learned friend to say in his skeleton that we need to await the outcome of the jurisdiction debate in Seculink number 1 to determine this issue, because we say, as you see from paragraph 25, the judge has said that it, as a matter of fact, it wasn't included by the MHA in the register or the in their determination. Now we say that goes further than absolving us from having to apply to court within a certain time period, as in the Seculink number 1 appeal on jurisdiction. If it's the case that it was never determined, including on a review, or put on the register, then it's not it doesn't fall within the moratorium in the first place. So it goes further than simply not having to apply to court, because we wouldn't need to. This is, if as I've shown you, the register never had the correct debt in, and when they were asked to review it and determine as the arbiters of the scheme what's in and what's out, you can see that they held that it wasn't, and therefore we enforced on that basis. So we say, based on the regulations, that the calling capital was not a moratorium debt in this case. My learned friend.
What does it mean to say that information has to be provided about the debt? You seem to accept that accurate information doesn't have to be provided because on any view they got the figures wrong. Why wasn't information about the debt, some information about the debt, provided to the Secretary of State, even if it was incomplete or inaccurate?
Because the scale of the debt affects, as I said earlier, what the creditor can charge interest on and what it can enforce against.
There's quite a difference between 9,000 and 95,000. Same order of magnitude.
Yes, but I think the register was. Be correct if I'm wrong. I think that mistake I think that was corrected on the register. So I think they did get it eventually the right way round, but it still is arrears rather than the capital. So I don't think anything turns on an original mistake as to in the letter that you saw.
That was a typographical error.
Yes, I think the register, will be correct if I'm wrong, the 95 this version of the register is correct for Interbay. It's Interbay 95,000. And we say it is substantive because creditors rely on that register. They can see that. And so do the debt advice providers. Because I said earlier, advising somebody on whether they have to pay over 1.3 million as opposed to 95,000 is a completely different kettle of fish. So the information that has to be provided about the debt, well, no information was provided about the debt. It was only provided about the arrears. And we say that that's substantive because, as I said, that affects what the creditor has to pay interest on, or can't charge interest on, and enforce. And this case is a graphic illustration because relying on that decision in the register, Interbay took possession proceedings only then to have it argued that the capital was called in was moratorium debt. It wouldn't have done that potentially had it been told and on the register that the whole debt was included. So one can see that there are real effects about getting the debt significantly wrong.
If as a result of this appeal, it turns out that this the whole principle was a moratorium debt, doesn't that just mean that the register has to be amended now?
Well, I wondered that, Lord, but it hasn't for the time. Still hasn't been.
Because presumably they'll await the decision we make. But if we were to decide that,
Yes, I think the point is it may affect. It wouldn't make what we did in respect of the possession order and the possession proceedings null and void, because at that time it wasn't a
well, there may
moratorium
be some
debt.
unravelling to be done.
Well, it would mean rather that those proceedings would not be null and void, which is what my learned friend is seeking. But I accept it. You could add, for example, you saw earlier an additional debt to the register. That hasn't been done as even now. So I don't, in that sense, it doesn't arise.
So
But I
does this
appreciate.
only go to the null and void point? It doesn't go to the substantive question whether we are able to determine that this is now a moratorium debt.
Well, until it's added to the register, it isn't a moratorium debt.
That's circular, isn't it? Because we've got to decide whether it should be added to the register.
Yes, no, I appreciate that, but it is important because it means that our possession proceedings and order are not in breach of any part of Regulation 7, so they stand. Can I deal with ground 2?
Yes.
Now, if we just look at what ground 2 comprises, and that's core bundle tab 215. This was the ground on which permission was granted by Lord Justice. The learned secretary was wrong to find the respondent was not prevented from taking forward step without permission of the court, under Regulation 76, requiring the appellant to pay interest that accrues on the debt. Debt is defined in ground 1 as the called-in capital, and taking enforcement action in respect of the debt, i.e. the called-in capital. Now, I had read that to be parasitic, that if you find that called-in capital is, you can't charge interest on it and you can't enforce in respect of it. And that's how I had read my learned friend's original skeleton on which permission to appeal was granted. And that is in the bundle at tab 4, page 44. So if you could look at 46 and 47, those were the paragraphs, and 45, that were in the original skeleton. And then when a replacement skeleton was filed to deal with the respondent's notice, apparently, 48 was added. And that seems to me,
When was that? When was it?
that was in, I think that was in November. So it was a while ago, I accept that. But I'm just doing a bit of archaeology to explain, because if you read 48, that is, as I explained earlier, a whole nother ball game to whether it flows from capital, calling capital being a moratorium debt or not, whether you can afford to accept that. But this is a whole nother territory. Now, what I'm not clear, even if one accepts 48 and needs to deal with it, what exactly, and I think my Lord Justice Baker picked this up earlier, well, what enforcement step is being attacked here? Is it the enforcement of security? Is it the fact that it's a mixed debt? Or is it the fact that it's in the same claim? And each step has its own different wording. And the reason I'm slightly confused is because in Bluestone, one had an order, a money judgment, which had conventional arrears, then the called-in capital, and then a possession order. If we look at the possession order in this case, which is in the core bundle, and we looked at it earlier, tab 17, core bundle. There is no money judgment. By the way, the reference to consent, I think it's agreed, is an error. It was a
Yes.
order made. So there's a possession order, and then the money judgment on a claim is adjourned. Whereas in the Bluestone case, one had an order, a money judgment in that order as well, which had for the capital, called in capital, and then the conventional arrears. So we can see that if one looks at Bluestone, which is in the Authorities Bundle 2, tab 18. If we could look at paragraph 37 on 390. So you see, he quotes His Honour Judge Parker's decision, and you can see at 103, that was the order that was made in Bluestone.
Yes.
So that's different to our case. So in that sense, there's no mixed debt, as it were. So I'm not, if my learned friend is seeking to draw that parallel, I don't understand how it's a mixed debt on that basis. Interbay is not seeking to enforce its possession order yet either. So in that sense, Bluestone was dealing with 77B, which is you can't enforce a judgment or order, but we're not doing that yet. So I'm just trying to find, one of the issues I'm struggling with is to find which target I'm having to attack from that paragraph 48. If my learned friend is referring, he doesn't expressly say so in paragraph 48, to regulation 77C, that prevents a creditor from enforcing security in respect of a moratorium debt. Now that was the other part, as my lord recognised earlier, of Bluestone, which raises quite difficult questions as to whether even if you hold security in respect of a non-moratorium debt, can you enforce in respect of the non-moratorium debt without somehow touching the moratorium debt? Now, as I say, I don't want to take unnecessary presumed points, and I've dealt with this in my supplementary skeleton, but I just wanted to inform the court of the nature of the lease as I understand it.
Thank you.
Now, in Bluestone, His Honour Judge Parker found the called in capital not to be arrears, but then he said the creditor still needed permission to enforce in respect of a mixed debt or mixed security. It's dealt with the first bit. Now, as I said earlier, it may be that my learned friend is saying that one doesn't contravene 77C security until you come to sell the property, and then one can think there might be undertakings or a suspense account to separate the date. But as I understand him to be saying, the act of bringing a possession proceedings would be enforcing security. So on that basis, it seems to be said, as I understand it, that that part of Bluestone could be relevant. And if we look at Mellor J's decision, I think I've still got it open.
Yes.
He sets out the regulations 7 on 388. So while we're in this document. So
Different numbering to you.
388 of paragraph 30.
Ah, I've got the wrong list in, that's why.
Yes, sorry, this is the
Yes, yes. Yeah.
Mellor J. So you see, it starts by saying the moratorium has effect in relation to moratorium debt. So it's making clear it's in relation to moratorium debt, not non-moratorium debt. And then again at 7.1, during a moratorium, the creditor may not, in relation to moratorium debt, take any of the steps in paragraph 6 unless permission is granted. And then if one looks at regulation 7.6 over the page, Judge is underlining, the steps mentioned in paragraph 2 is prevented from taking are any steps I think he's actually left out the words in relation to moratorium, but the President says take any enforcement action in respect of a moratorium debt. So it's making clear what it's respect of. And then you'll see it's at 7, I've mentioned B. We're not trying to do that yet. And then C, so that's the other aspect of Bluestone. The other one that's relevant that isn't listed out here is bringing a claim in respect of moratorium debt. That's J. Now, having explained that, Mellor J upheld the decision of His Honour Judge Parker. And if we just go to 396 of this paragraph 60, he effectively held that even if you were seeking to enforce in respect of moratorium debt, non-moratorium debt, somehow the words in respect of must be determined widely. And then he added his own, in addition to endorsing what the judge had said, he adds one reason of his own, at 61.
Yes.
And then just while we're on this, a point you asked about earlier, paragraph 28 at 387. This is Justice Mellor explaining the significance of the point that Ford asked me about this morning and why he felt the appeal wasn't academic. He said it's likely to arrive in every situation involving a mortgage in arrears on secure property where the debtor has entered a moratorium.
Yes.
So he considers that it has quite, and His Honour Judge Parker said the same thing below. Can I, and then just for completeness, the judge heavily relies on almost in full what His Honour Judge Parker had held. So I better just take you to 391, page 391, paragraph 38. And that is what His Honour Judge Parker said about 77C. And perhaps if I could just ask the court to read that very briefly.
Yes.
Can I give 2 examples of why this can't be right, that even if you enforce in respect of something that's got nothing to do with moratorium debt, that you are dead by association, effectively?
We don't see any of this reasoning in any of the decisions under appeal here, do we?
Well, no, but I don't want to... Leonard said, I think this morning, he was relying on 77C.
No, indeed, I understand the point, yeah.
But you're absolutely, it wasn't argued below.
Okay.
And it's only, I think in the Seculink case, they're reserving this to enforcement, the stage, to have this debate.
Well, be as quick as you can, please, Mr. Ridley, because I have an eye on the clock.
I apologise, my lord. I was just wanting to inform
No,
the
no,
court.
That's right. No, no,
I
I
think
think to
there are-
apologise. I'm just anxious about the time.
Cool.
So we've read what Mr. Justice Mann has
Yes,
said.
that was His Honour Judge Parker, which
Quoting the
he
Parker, yes.
simply said he agreed with it.
Yes.
And added the reason you saw about the purpose of interpretation. Can I just give two examples why I think this can't be right? Suppose a creditor sought a money judgment, as my Lord Justice Zacaroli said earlier, entirely limited to non-moratorium debt, whether it be the called-in capital if that's not moratorium debt or something else. There's nothing stopping that creditor obtaining a charging order solely for that non-moratorium debt, enforcing it and realising the sale proceeds to cover that non-moratorium debt. It could then give any surplus to the debtor. Why should secured creditors have to pretend they are unsecured creditors, get a money judgment, get a charging order, and realise it for the non-moratorium debt? If you can do what I've just described under the regulations, it's perfectly possible to distinguish between a possession order based on moratorium debt and something completely different. Take another example. Suppose someone had paid everything up to date and then they are put into a mental health moratorium. Despite that, the creditor could enforce in relation to one missed payment after the moratorium falling due without any need to obtain permission. So there are a number of other reasons why we say the words "in respect to moratorium debt" are limited to that. I won't go through them all given Lordship's indication, but can I just give you the reference that they are at paragraph 16 of my supplementary skeleton
Yes.
as to the reasons why Bluestone cannot be right about mixed security. And I've given you earlier the insurance example, which would be a non-moratorium enforcement based on non-moratorium debt, and how on Bluestone, even that would fall foul of regulation 77C. And we say you don't need to add, as His Honour Judge Parker said, the word solely in front of enforcing in respect of a moratorium debt. But we say the problem with Bluestone is you decide under Reg 5 and 6 what's a moratorium debt and what isn't, and what the exclusions are, to then say, despite me having excluded debt, I've now got to ask for permission before I can even rely on my exemption, simply because another part of the debt is moratorium security held, is non-moratorium debt. We say is a stretch. There are other reasons that I've given. Melajay was troubled by the idea that if someone had moratorium arrears and was suffering a mental health crisis, then it would be odd to allow repossession of their home, even in respect of a non-moratorium debt. But we say that is the balance, though it may seem, of the regulations that post-moratorium arrears can be enforced against. And I think the answer that's sometimes given is, well, you can just ask for permission and then you can enforce. But that's not really an answer, because Regulation 7 is aimed at things that are moratorium debt in the first place. And if one looks at the criteria for granting permission in Regulation 7.5, Volume 1 of the Authorities, tab 4, 28, page 28, one's looking as to whether it's reasonable and whether it's detrimental to the debtor and the moratorium. It doesn't allow you to consider the creditor. For example, if I was a creditor and I was facing bankruptcy, unless I could enforce this non-moratorium debt, that can't be taken into account. One's looking at the detriment of the debtor. And if Melajay is right in Bluestone that there is nothing more detrimental to a debtor's mental health than eviction, then permission will unlikely ever be granted in the context of when you are seeking possession or enforcement, even based on a non-moratorium debt, if some of the debt or security is held in respect of moratorium debt. Finally, His Honour Judge Parker says the answer to this is the fact that under Regulation 7.6a, you can charge interest in respect of a non-moratorium debt. You just can't enforce. But it strikes me as odd as why the words "in respect of" in Regulation 6a would be any different? Why can you charge interest on a non-moratorium debt but can't enforce on it? It doesn't make any sense. It's quite possible. And of course, this would arise upon a sale, finally, because until then, you wouldn't have, it would only be if you had a surplus from your non-moratorium debt or enforcing security, that you would then be in a position, potentially, as to what to do. And then, of course, it could be paid into a surplus account, it could be paid to the debtor, or otherwise ring-fenced. So the idea that a surplus involving moratorium debt from security may never arise if there isn't enough equity left in the property. Can I then turn to ground 3 finally, which was ground 2 below? This is the point. I think that the quickest way to deal with this, my lords, is to look at the judgment of Her Honour Judge Evans Gordon, core bundle tab 8. And if I could ask the court to read paragraphs 35 to 37 on page 95.
Yes.
Really, it's paragraph 37,
Yes, we read that.
which we say is a complete answer. So it would be abusive to bring 2 proceedings. It's not necessary. The court can easily ignore different parts.
Thank you.
Just to deal with 2 final points on this, my lord, and then conclude. My learned friend says that a breach of the Finance Acts for unauthorised occupation is a default, just like failure to pay the arrears. So it's the same thing, but that's not right. It's a separate. I don't know if I give you perhaps the references, but the ground for possession based on the unauthorised tenancy was a separate ground for possession in the particulars of claim, at paragraph 5b, and that's core bundle 20, pages 117 and 178. It was dealt with separately in the possession witness statement at paragraph 8. Mr. Wright, supplementary bundle tab 4, page 8, and in paragraph 9 the skeleton before the Deputy District Judge at supplementary bundle tab 6, page 56. So it's not the same as it wasn't as the debt claim. It's a non-financial breach, and the acceleration of the loan was based on the non-payment of the money. And finally, to deal with one point my other learned friend takes on ground 3, it's important to remember, as has been famously said, that a mortgagee is entitled to possession before the ink is dried on the mortgage deed. So the quantum of the arrears, for example, that one is enforcing against, or the different grounds, do not matter. As is said in that authority, it's Four Maids and Dudley Marshall, decision Mr. Justice Harman in 1957, and just for reference, it's authorities volume 1, tab 5, page 53. A mortgagee's right to possession arises before the ink on the mortgage is dried. It is subject only to an agreement by the lender not to enforce for compliance with the mortgage terms. So we say the failure, the breach in relation to the unauthorised tenancy is a breach of the term. It's not related to the debt. The ground for possession is separate and standalone. finally, my learned friend says in his skeleton, it's common to bring separate possession claims, such as Section 8 Housing Act claims for 8 weeks rent arrears, and alternative possession claims based on Section 21, 2 months' notice to end the tenant for possession. However, that is not usual, and also, even if one does that, those claims are brought at the same time and heard together because of their obvious overlap and to avoid inconsistencies. Unless I can assist the court any further, that deals with grounds.
No, thank you very much. Thank you very much, Mr. England. Now, Mr. Morris, we're going to have to be quite swift, I think. You want to talk about something on legality, do you?
Indeed, my lord. This is the fourth hearing at which I've sought to bring these principles onto centre stage. It's irresistible perhaps to pick up on your Hamlet reference earlier to suggest perhaps that my enthusiasm is matched by Tom Stoppard to bring Gildenkrantz and Rosenstone and Gildenkrantz even back onto the stage. So briefly, my lord, it is always possible to find X or Y authority which treats these principles with more or less enthusiasm. I'm not going to go through them because they are ventilated at length in the skeletons and analysed comprehensively in chapter 27 of Benyon. But my lord, in my submission, what remains clear in our law is that it is a principle that legislation should not be construed so as to have the effect of interfering with property rights and economic interests in the absence of express language or of necessary implication. And if authority for that is required, my lord, I will refer you to R on the application of O and Home Secretary. It's in the Interbay Authorities Bundle, tab 12, page 238, at the end of paragraph 43. I won't take you to it, but Lord Hodge described this as a rigorous rule of statutory construction. And my lords, it applies a fortiori to regulations which are made under a delegated power. And the delegated legislation itself here, of course, delegates a decision-making power to a debt advice provider or a local authority. And you were taken to the passages from Benyon by my learned friend, Mr. Gunn Cunningham, earlier, and I think my Lord Justice Baker picked up on what is suggested there, which is that delegated legislation must itself be construed strictly. I think that the editors explain it as an expectation. In my submission, that expectation must be right. The expectation, just for your notes, is in the Seculink Authorities Bundle. It's tab 7, page 138 at the bottom, going on to page 139. My lords, very briefly, there are just a number of submissions which flow from those principles. The first is that even where Parliament clearly intends some degree of interference, legislation ought to be construed as interfering with those rights no further than the statutory language and purpose require. Authority for that proposition is the Supreme Court's decision in Francis, which is referred to paragraph 24 of my skeleton argument. But there is another way of expressing that, my lords, and this is a point I'd like to underline, if I may. What essentially this means is that where there is ambiguity about what Parliament intended in enacting a piece of legislation, or what a departmental draftsman has drafted, the legislation should be construed strictly. So, in other words, if there is genuine ambiguity that cannot be resolved by classical methods of interpretation, it should be resolved in favour of the person whose economic rights would otherwise be interfered with. That rests on the same principle as the same conceptual basis, the principle against out for penalisation. That was recently endorsed by the Court of Appeal and indeed by the Supreme Court in Rackison and Jepson. That's in Interbay's Authorities Bundle. I think my Lord Justice Maker may recall that case because the Supreme Court robustly upheld a decision of this court over which he presided, and that followed a hearing at which I submitted that principle was engaged before him. The case on which Mr. Westgate relied, which is the Medway case in tab 4 of the Seculink Authorities Bundle, that was one which, as my Lord Justice Baker put to him, was essentially one where Mr. Justice Neuberger reached his conclusion applying a classical approach, and having done so found that the principle added nothing. It was not a case of genuine ambiguity where I maintain that the principle should be resorted to. So, turning then to apply those to this case, in my submission there is, simply put, real ambiguity here on the language of the drafting. The words "in respect of" plainly can mean what Sir Anthony Mann thought that they meant. In other words, that the effect of a moratorium applies only to arrears on a secured debt, leaving the balance of the debt excluded from the moratorium. That is an available interpretation. In my submission, this is not a case where the hurdle of express language or necessary implication is surpassed. In other words, if Sir Anthony Mann was wrong to think that on a classical approach my case was right, he was left, or would have been left, with drafting which was at best ambiguous, and that would have opened the door to the principles which are engaged, and that ambiguity should then have been resolved in favour of secured creditors. Not least, my lords, given that the court is construing delegated legislation, and not least, of course, given that many creditors will have advanced loans to debtors long before these regulations had even appeared in the Conservative Party manifesto and lumbered over the horizon. Now, I've done that at some considerable speed.
Yes, that's very good.
If I may, just want to use the reigning time to make some submissions on the specifics of the wording.
Yeah.
In my submission, there are a number of pointers towards Sir Anthony Mann's conclusion being right. The first is the linguistic pointer that Mr. England addressed you on. Essentially, on Mr. Westgate's case, it is not necessary to include the words "in respect of secured debt" in Regulation 54A, because if one stopped at arrears, they would have the effect for which Mr. Westgate contends. Therefore, Parliament ought to be presumed to have intended those words to have some effect. Now, the second point is in relation to capitalised mortgage arrears, and here, my lords, I'm going to attempt to respond to the point that my Lord Justice Zacaroli put to Mr. England in argument. I should say, as Mr. England volunteered me to do so, I heard the wheels of the judicial bus approaching at some pace. But that notwithstanding, here we go. If I could just make sure your lordships have got in front of you Regulation 2 and the definition of arrears in the authorities bundle. If we do it from Interbay, it's behind tab 4 and it's on page 20. So, arrears in Regulation 2.1. Now, my Lord Justice Zacaroli noted that the words fallen due appeared there, and he put considerable emphasis on those words. Of course, the definition doesn't stop there. The definition is a sum which is fallen due and which the debtor has not paid at the date of the application for a moratorium in breach of the agreement. So there are two requirements. The sum must be due and it must be unpaid in breach of an agreement. So due and owing, in other words. And I paused there. Well, I didn't pause, but I go on to note that Mr. Westgate relies on the decision of this court in Deutsche Bank and Vic, which I think my Lord Justice Males will recall, because there I unsuccessfully made submissions to him about the meaning of arrears in the context of the Limitation Act. But Mr. Westgate's point is that something can be due, a debt can be due before it is due for payment and therefore owing or overdue. And he relies on it for that proposition. And that's important, my lords, because in the context of arrears, capitalised mortgage arrears, of course, are due from the point that they are added to the security. They have fallen due, but they will not be unpaid in breach of the agreement because they will have been added to the balance to be paid over the duration of the term. So in other words, they will satisfy the first requirement of the definition of arrears, fallen due, but they will not be unpaid in breach of the agreement. Now,
well, they were unpaid in breach of the agreement, but it's been resolved by capitalising them rather than any other way.
I accept, my lord, that may be possible, but of course the terms of the agreement may simply state that the interest will simply be added to their capital over the term of the mortgage, on which interest will be generated to be repaid at the end of the term. That is another legitimate way of structuring a loan. But I accept that there may well be, there could be cases where the parties essentially collateral to the loan agreement do reach the view that arrears will be capitalised, essentially by way of settlement of a claim that they would otherwise have. But nonetheless, there is still a requirement that there be a breach of the agreement, and once arrears, or once capitalised mortgage arrears have been added to the balance, they are no longer unpaid in breach of an agreement. And that is the essential point, it seems to me. Because as Sir Anthony Mann appreciated below, on Mr. Westgate's case, there would be no need to carve out capitalised mortgage arrears, because once added to the security, they would not in fact be unpaid in breach of the agreement, and they would become within the scope of arrears from the point where the whole of the balance became due. So what Sir Anthony Mann was alerted was the fact that Parliament can be presumed to have intended something by carving out these arrears. And for the first time in a skeleton argument, I've resorted to colour coding at paragraph 30. I hope that was of some assistance to your lordships in trying to get your heads around the way that these interlocking definitions work. But if you peer at the language with all of the definitions incorporated into them, it remains in my submission unopen to Mr. Westgate on the language of the statute to contend that capitalised mortgage arrears are ever included within the scope of arrears for the purpose of the regulations. And so that, of course, just begs the question, why are those words there? Why has Parliament opted to carve them out? In my submission, it is to make clear that sums which are added to the outstanding balance to be paid over the term are treated differently under these regulations, even when fallen due and not repaid in breach of the agreement. And consistently with that, of course, as Mr. England has submitted, the outstanding balance must therefore be treated differently in the scheme of the regulations from arrears on that balance. And in my submission, the scheme of the regulations isn't so much about distinguishing between principal and interest, it's about distinguishing between an outstanding balance and arrears on that balance, arising out of that balance, which are distinct from the balance itself. And just finally on capitalised mortgage arrears, since I've been volunteered to deal with it, if I can just address the possibility that instalments or payments of instalments in a repayment mortgage may include a small amount of capital in the monthly repayment. Mr. England, I think, submitted that this means that capital is always excluded from a moratorium. It's open to the court, I suppose, to take that view, but there is a lesser alternative, if you like, available, which is that a missed instalment is in whole within the scope of the definition of arrears in respect of secured debt, even though it includes some capital element. And on my theory of the regulations, which I think is really the same as Mr. England's, the distinction is between an outstanding balance and arrears on that balance. And so through that lens, it works, it hangs together.
Yes.
How does that work when you get to the last instalment?
My lord, I accept, and I confess I was thinking about this yesterday. It seems to me that may be said to be an absurdity that arises, but we know from the commentary in Benyon that new statutory schemes...
Well, the last instalment would include an element of interest, won't it?
Yes.
Even in a minuscule element.
Well, it would include a minuscule element of capital, and there would still be a balance to be paid. So on that
Sorry,
case...
are we on a repayment mortgage?
Yes, assume, my lord, I think... as
On a repayment mortgage, the last instalment is nearly all capital.
Yes, necessarily. So there will be a residual capital balance outstanding. And so the analysis works. When taken to that extreme, it doesn't necessarily feel as elegant as it does when we're looking at something that's happened in the middle of a mortgage or an interest-only mortgage or a case where the whole of a balance has been called in. But that extreme example in my submission doesn't collapse the logic which underpins the reasoning that I'm advancing to your lordships now. There is also an obvious policy rationale to the interpretation which we impress upon you and which Sir Anthony adopted, which is that, as I think we're all clear, that it is might be thought desirable that a creditor should not lose interest on the balance of a secured debt which has been called in or is overdue for payment, because, as I submitted below and maintain here, that would essentially involve the forcible extension of the term of a mortgage for what might be an indefinite term, an indefinite period, without compensation. And my lords, it's important in my submission not to lose sight of the fact that that might have disastrous consequences where the lender is not an institution but an individual who is themselves at risk of bankruptcy, or a case where the lender has themselves borrowed the money on the market at an interest. And it also might be disastrous where, as here, the lender is the holder, or certainly in my client's case, of a second or third ranking charge. there is every possibility of their security effectively being wiped out if the balance due to them is included in a moratorium, but a first charge holder continues to charge instalments of interest as the term of that first charge runs on. And those policy factors in my submission reinforce what I've said today and what Sir Anthony thought below. I covered my laws. I think everything that I intended to cover at considerable lick.
Well, thank you very much. That's very, very much to your credit. Anything else you want to say?
My lord, unless there's anything else you would like me to say, to which I think I know the answer, I will subside.
Just one question. So we dealt with the last instalment of a
Yes.
typical instalment mortgage. Point raised against you was, what about a secured loan where the loan is repayable, let's say in 2 tranches, to use a
Yes.
natural term? What about that?
Well, in that case, the payment of the first tranche would be, if it were not paid on time, that would amount to arrears in respect of a secured debt, because there would be an outstanding balance to be repaid. And in this case, in Seculink's case, the loan was a short-term loan for 4 months, the whole balance becoming repayable in 4 months. What we say there is that the arrears on that debt are the interest which is accrued since, but where an agreement provides for a single repayment, that instalment or that repayment, because it isn't an instalment, it's the redemption of the loan at the term date, would never be an arrears in respect of secured debt. It is the balance of the secured debt itself which falls due.
So the first tranche, if not paid, would be arrears. When the second tranche falls due, that's the whole thing.
Essentially, that is not really an instalment. That is not that is the falling due of the balance on the term date of the loan.
Thank you. Thank you very much, Mr. Norris. Now, Mr. Cunningham.
My Lord, I've got 3 brief points. The first point is in relation to ground 2.
Yeah.
Page 44, paragraph 48, which is
Page
44 of the core bundle.
Yes.
I accept, as Mr. England has said, this paragraph was added to the replacement skeleton argument after permission to appeal was granted.
Yes.
But I thought that was permitted in the sense that you're allowed to review your skeleton argument after permission to appeal was granted. But,
Do you accept it raises a new point?
well, not entirely. I mean, I accept the mixed debt point is a new point. But the way,
I think that's Mr. England's point.
can I just show you the way it was put in front of the judge below, very briefly? The grounds of appeal, the amended grounds of appeal are at tab 13 in the same bundle, page 131.
So we're now looking at ground 2.
Yeah, so and this ground 2 this is the grounds of appeal below.
Yes.
And what I was saying there is ineligible because enforcement action required permission, both in relation to enforcing security and bringing proceedings. But I didn't expressly take a mixed debt point. I accept that. I took the view that ground 2 in this appeal, which is at page 15, was sufficiently wide to take the point, and the point has been taken since the 9th of October last year. So that's the position. So I would invite you to let me take the point. Although it wasn't taken below, it's been in my skeleton argument since the 9th of October 2024, and it's encompassed within my submission ground 2.
Well, we'll consider that. What else do you want to say on that point, if anything?
Well, I rely as I did on the judgments in Bluestone, Mr. Justice Mellor.
Yes.
He was dealing with security, The point I'm taking is in relation to bringing proceedings. But in my submission, it's the same point. You can't bring proceedings in relation to a non-moratorium debt without permission of the court where there's a moratorium debt.
Thank you.
The second point I wanted to deal with is really in my skeleton argument. It's on page 49. It's the moratorium debt point about which information has been provided. So I've set out at paragraph 66,
Yes.
regulation 6C.
Yes.
And my answer is below. The short answer to this ground is that information was provided to the Secretary of State about R's debt, but it was sorry, that should be A's debt, or R's debt, yeah, R's debt, but it was incomplete information. It's all about how you construe what information was given. And then I've two letters, which are the page references are given. If I could just take you over the page. This is the letter from the debt advice provider to the respondent solicitors. We feel we must explain that due to the nature of the mental health crisis screening space, the information we received is very limited, obviously only the name of creditor, so this information is added to the moratorium. As you receive more information, the solicitor portal was updated. We will advise debtors the eligibility of debts included, especially if the debt was not due at the time of the debtor's entry onto the moratorium. And then they say, the paragraph 69, bottom of the page, Mr. Forbes' representative, that's me, alleged that the full balance of secured loan had fallen into arrears. A full repayment was requested on 21st of March 99 from Interbay. If correct, this would mean the full balance of the loan was included in the moratorium. So it's a question of the information that's provided to the debt advice provider. And in this case, incomplete information was provided. So it is, in my submission, a moratorium debt because information about the debt was provided, even if the information was wrong.
Information provided to the debt advice provider. It doesn't have to be provided to the Secretary of State.
Sorry, yes, to the Secretary of State by the debt advice.
Yes.
And my third and final point is in relation to ground 3 and it's page 46, paragraph 56, where the judge says, I've quoted it, so severing an unauthorised letting claim from a possession claim, or treating them both as null and void. And I say they should have issued two separate claims.
Yes.
The judge said counter to the principle that a claim must include all relevant cause of action, a claim not precedent multiple claims. And I've used an example of a Section 21 notice under the accelerated procedure and the Section 8 notice under normal Part 55 claim. And those are brought on different procedures, heard by different courts at different times. So it's quite common in a possession claim to bring separate claims. And it'd be nothing wrong in bringing a claim in relation to a non-moratorium debt and then bringing a separate claim if permission was granted in relation to a moratorium debt. Those are my submissions.
No, thank you very much. Now, Mr. Westgate.
Yes, I've got a short group of submissions on the in respect of point and then something on CLAs. So far as in respect of is concerned, Mr. Morris urged you to accept that his reading or his preferred reading on was an available one and therefore should be chosen given what he says about principle of legality. Our position is that it simply isn't available for largely for the reasons that I said in opening. But where we're now left is that there are, it seems, at least 4 possibilities as to how one distinguishes between the arrears and the thing that gives rise to the arrears. One is based on an outstanding balance, which is the idea being canvassed this afternoon. Then there's capital and principal. Is that the right distinction? And if so, how do you decide what's capital and what's principal? And then there's a third one, which is it depends on instalments or the periodic nature of the payments. And lying behind that is a fourth possibility, that it all depends on how the debt is structured, which for reasons I gave earlier would be inconsistent with the protective nature of the regulations, because it would make the, in effect, the drafter of the creditor's agreement the master of whether the regulations applied or not. And on top of all of that, there's no explanation as to how it is that any of that is to be found in the regulations, or what the basis is for drawing the distinction in the regulations, or how the court should go about it. So we're left with a position where the court can't rectify this by reading words in, or it's deleting words, or anything like that, overstepping the boundary between interpretation and legislation. The fact is that this is a new scheme with a complex set of regulations with their own terminology. It's fair to say that it's a scheme that may have a few rough edges, but the solution to that isn't interpretation against the kind of background I've described. You will have noticed that Regulation 40 provides that there has to be a review every 5 years. And the first review is due almost exactly a year from today. I think it's the 5th of May. And these are the kind of problems, if there are problems, where it would certainly be appropriate for the court to express its view, but they're to be picked up on a review of the regulations. I've got a couple of other shorter points about the in respect of point arising from Mr. England's submissions, where he suggested that if the whole debt fell due, then there's nothing for arrears to be in respect of. That, of course, only is true if you insist on a colloquial meaning of arrears. If you read in the regulations and the definitions, then of course there's something for the arrears to be in respect of. They're in respect of the agreement. The second point I make in relation to this is the group of other provisions in Regulation 5.4 that we rely on, where in respect of is used council tax, domestic rates, student loans, and fines. We of course accept that it may not always be the case that a broad term like in respect of bears exactly the same meaning in wherever it appears. But what we rely on here is the key point that in each of the cases where that term is used in the very regulation that we're concerned with the very point about identifying what is an intelligible debt, the term in respect of covers the subject matter to which it relates. And there's no instance in that context where it does anything else. So that's a strong point that we say why in respect of should bear the meaning that we say. So far as the capitalised mortgage arrears are concerned, the point was taken that the appellants don't explain why it is that capitalised mortgage arrears are excluded if the appellant's explanation is correct. But that in respect isn't the case, and we refer to our skeleton for that. And the explanation that we put forward is, we suggest, in line with the analysis suggested by Lord Zacaroli, where if one goes back to the definition of arrears and capitalised, then the question is whether, notwithstanding the capitalisation agreement, the sums remain or might arguably be thought to remain within the definition of arrears, because they had fallen due. They had fallen due under the breachment agreement with the creditor, and that of course raises the question: well, what is the agreement to which one is referring? Is it the original agreement, or is it the agreement to capitalise the arrears? And someone might well think that, notwithstanding the fact that arrears have been capitalised, they didn't lose their character as arrears. and therefore they ought to go into the moratorium. And someone thinking like that, we suggest, would be in good company, because of the decision we rely on at the House of Lords in Oswald. We give the references in our skeleton argument, but that was in effect it was a tax case where the arrears of interest had been capitalised, and the question arose when they'd been paid for the purpose of tax treatment, and they weren't paid on being capitalised. They remained sums that were due, and the effect of capitalising them was simply to add them to the security and to enable them to attract interest. So, armed with authorities like that, one could well be in a situation where the arrears, but for the express exclusion of capitalised mortgage arrears, would have ended up going into the moratorium rather than being outside the moratorium for the period during which the mortgage hadn't been called in. And as we suggest in our skeleton argument, the key to this is considering a situation before a mortgage is called in, but there are capitalised mortgage arrears. And on the appellant's reading, that enables them to stay out of the moratorium, and it enables them to attract interest in the same way as the rest of the capital. So on the appellant's analysis, there clearly is work for the definition of capitalised mortgage arrears to do, without having to resort to the anomaly that the judge was exercised by. And the way that the judge, the judge didn't approach or didn't deal with that argument. Oswald wasn't cited to him, but the same argument was made. So far as Mr. Morris's analysis goes, he follows the reasoning of the judge to say that if capitalised mortgage arrears are already dealt with by an agreement between the parties, the effect of which is that they're not going to be enforced or aren't treated as falling due and being something that can be claimed by the creditor, then the effect of that is that they don't need any special provision to be made, and therefore the appellant's argument is flawed, according to Sir Anthony, because it's unnecessary to produce any. It has no work to do because the arrears are already unenforceable. But that doesn't deal with the point I've just made about which agreement about them potentially still being thought to be arrears for the purposes of going into the moratorium. But also, if the argument is right, then it ends up proving too much, because it's an answer to the solution chosen by the judge as well, because it wouldn't be necessary to make special provision for the capitalised mortgage arrears in order for them simply be treated as the same way as capital, whichever way that falls. Because if the parties have already agreed it's going to be treated like capital, then why do you need to have any special provision? So the argument advanced by the judge undermines the judge's reasoning more than it does the appellant's reasoning. The judge was also placed slightly less emphasis on the further anomaly that he was concerned about the possibility that you could have a difference in treatment between a debt that's called in the day before the moratorium and the day that's after the moratorium. It's something that was developed by Mr. Ingram this afternoon. But the difficulty with that is it's the real complaint isn't that that's an anomaly. That's simply the way that the regulations work, and many regulations do work like that by drawing bright lines, and they have to do so in cases fall on one side of the line or the other. And the suggestion was made, well, what if a debtor waits and deliberately doesn't pay, hoping that they can provoke a call-in? Of course, if they did that, then that would be a good ground for alleging unfair prejudice on an application to review. The point was also made that this could be something that could go on for a long period. And you already have my point that you can't use hard cases to construe the regulations. But the point is also valid that that's not something that only applies to secured debts. And although there is some secured debts that's clearly differently treated under the regulations, we don't have any explanation as to why that is, that would explain why it is that they should not only be given preferential treatment under the clear wording of the regulations, but that the court should then strain to keep them out of the moratorium when unsecured debts would clearly go into the moratorium with all the adverse effects that the respondent suggest. So would you be able to on that? Unless there's anything else.
Thank you very much, Mr. Westgate. Thank you. Well done, everybody. You've got finished at 4:30. I hope everybody feels they had a fair opportunity to put their case. I think we all think we did. We're very grateful to you all. Very interesting points. We're going to take time to think about them. We're reserving our judgment. In due course, you will be sent copies of our draft judgments. That gives you an opportunity to correct any typographical or other minor factual errors. It's obviously not an opportunity to re-argue the case. The draft is sent out under an embargo. Please bear in mind the word of that embargo. It's not to be shared with anybody other than those to whom of whom we have notice. Remember, that is a contempt of court if you were to breach the embargo. We'd also be grateful if in due course you would draw up orders reflecting our decision as set out in the judgment. If there are any matters, ancillary matters upon which you are not agreed, please will you send us short written submissions and we will resolve those outstanding issues on paper. We're very grateful to you and to those who sit behind you for the hard work in this case. Thank you very much. There's one supplementary point I should just remind myself. I'm reminding myself, I see Mr. Clark is about to prompt his leader on this point, and that is that you're going to submit, are you not, Mr. Westgate, a document in respect of, or have opportunity to submit a document in respect of the permission to appeal?
I think we probably don't.
You feel you're going to just
can we
nail your colours to the mast of your skirt?
Well, now that we've had the benefit of listening to what's being said, but can we have a few days to think about it? But I don't anticipate that we will do.
We'd be grateful if you could provide those further supplementary submissions, which need not be long submissions. Yes. Well, rounds by 2 o'clock on Monday.
Yes, yes. And of course, we'll tell you if we're not going to do them.
My lord, I was going to say I wasn't planning to put in a paragraph, I think paragraph 19, 3-page submission, but I'd better reserve my position if Mr. Westgate is going to add anything to what he said.
Would Friday week be sufficient for that?
My lord, I will grab that with both hands. Yes.
Thank you very much. All right. We're very grateful to you. Thank you.
Court rise of people.